We are not in hurry. We will hear you all in length.
We are grateful, my lord. We are absolutely confident, my lord. Yes. Actually, we are grateful that your lordships took so much, my lord's interest and my lord constituted the bench, my lord, despite the pressure of your lordship's time. We are my lord, really grateful for that.
That's really wonderful. जैसा कि आप सब देख रहे हैं, हाई कोर्ट जो है हियरिंग चल रही है हिजाब के मामले पर, हेडस्कार्फ के मामले पर, तो यहाँ पे आप देख रहे हैं चीफ जस्टिस इसे लीड कर रहे हैं एंड दिस इज ऑल कमिंग लाइव। तो आप सब बने रहिए और कोसे कोसे इसके अंदर जो है सीनियर एडवोकेट इस पर बात कर रहे हैं।
We can follow what we say. We are in different locations. We don't have the benefit of that note.
It will be done. It will be done in the next.
Both are friends.
My lord, friends and neighbors in Delhi, my lords.
Yes, we are neighbors in Delhi, but Mr. Puvaya is today in Bangalore, I believe.
I don't know.
In fact, when I said Muskuraiye Lucknow mein hai, it was Mr. Puvaya who first called me up and said, smile a bit more when he saw me rather. Please. I'm sorry, my lords, I have one request for the court master. My junior who's assisting me Mr. Pranjal Kishore keeps getting locked out from the proceedings and he can't follow instructions. He is in the waiting room. If he may kindly let it.
एक और खास बात जो यहाँ पर कही गई है चीफ जस्टिस की तरफ से, उन्होंने रिक्वेस्ट किया है सभी मीडिया से कि आप लोग जो हियरिंग चल रही है उस बीच का कोई भी फ्रेज या उस कुछ डायलॉग उसका लेकर आप उसे मीडिया में पब्लिसाइज ना करें, क्योंकि ये ओरल हियरिंग चल रही है, एक डिस्कशन चल रहा है, इसमें से आप कोई कंक्लूजन ना निकालें जब तक कोर्ट जो है पूरी तौर से अपना फैसला नहीं सुनाता। तो इस तरह से उन्होंने मीडिया को रिक्वेस्ट भी किया। तो हम सब चाहते हैं यही है कि इसलिए मैं भी आपको ये डायरेक्टली लाइव दिखाने की कोशिश कर रहा हूँ ताकि एग्जैक्टली क्या क्या ये हियरिंग चलने वाली है। ये हियरिंग इतना 5-10 मिनट में खत्म नहीं होने वाली, कम से कम आधा घंटा से 1 घंटा इस लगने वाला है। तो आप सब बने रहिए। उसके अलावा भी मैं जैसे ही ये प्रोसीडिंग होती है इसका सारा निचोड़ क्या है, सारा अपडेट क्या है, मैं आप तक जरूर पहुंचाऊंगा।
Please, man.
If it is for the final hearing, well and good. There is no problem.
Please, my lords, I am mindful of court's time. I am also aware of the pressures on the court.
Unfortunately or fortunately, for whatever reason, there has been another set of students who are coming now to the colleges wearing bhagwa, saffron shawl, saying that also depicts our religious symbol and we must be permitted. But this led to a large amount of commotion and some sort of disturbance in educational institutions, for which the state government took a decision to close down the institution for 3 days, which expires on Friday. But in this context, in fact, I wanted to make that submission before the watches, but since Mr. Hegde started writing. Therefore, in that context, my submission before your watches would be, notwithstanding the claims and counter claims which is sought to be made before your watches, an arrangement requires to be made for it to be conducive ultimately for the education and sciences. Now, as on today, there is an order passed by the state government stating all that we have said is each educational institution shall decide its own uniform. We have not said that this should be uniform, this should not be uniform. The pursuant to which what some institutions have taken a decision, what should be the next. The question is not whether any of the students would disregard to that those decisions, they go and take part in it. Pending that, now of course for two broad issues. One, now they are saying that the government did not have to provide the pass. Secondly, the larger question of Article 25, what means they say is inherent within the religion is activity itself, part of an integral part of the religion. To wear an headscarf, therefore, by preventing me from participating in this, you are violating 25. That seems to be larger. Pending that words, my submission and my lord's may straight away on my submission. We need to start the institution. We want the children to come to college. But we can't start the institution in this atmosphere where one set of the students say they will come and wearing headscarf, the other person say that we will cut shawls, etc., depicting their religious. We say not that we want to start the education. We want a very congenial atmosphere among students. Pending disposal of a final adjudication, this is one good option which lodges can be examined. But they must go back to the status quo and take
Lord, there is absolutely
any particular.
Lord,
I'm complete, but they have.
I'm sorry. I'm sorry.
So insisting on any particular dress code, whatever has been prescribed by each of the college development, they must again have on. Subject of what finally lordships are to hold that they really like exists of consequences. So this is something which I want to place on the part. Whereas a state board we are concerned with the apart from the law and order situation of the life of the students. There are a large number of students who are more concerned with them, but they have been now not kept away from the education institution. It has to start in this manner. I'm placing on record this. Arrangement will cause no prejudice. In fact, it's to facilitate the running of this education.
That the first concern of everyone should be that at the earliest the education institutions shall reopen and they shall start imparting education to the students. All these issues which are there, they are before the court, and then the court will consider them. Absolutely. But whatever is that we all have to agree that some sort of arrangement shall be made where the education shall not suffer. Absolutely. Not only that we don't think that there can be any dispute to this. That our endeavor should be that the education of the students shall immediately start and without any disturbance.
Because of this pandemic, already 1.5 years students left.
Yes, now things were coming to back to track, coming to track again. But now this issue has started where the schools have to be closed. This is not a good situation.
I completely agree, my lord, with what the learned AG has said, that the schools and colleges should reopen at the earliest. And my lord, there is absolutely no joining issue with that, my lord. And my learned friends also will agree. My lord, what I was suggesting is, as Mr. Hegde put it, my lord, this is not a case of uniform, my lord. My lord, nobody is saying this is not a case, my lord, where the students are saying we will wear a different uniform. Please, my lord, as far as my clients are concerned, this is not the issue at all. Exactly. The issue is simply this: the students will wear the school uniform. The only question is, my lord, that they want to wear a headscarf of the same color as the uniform. And my lord, the state is today saying by a GO that they can't wear that headscarf. Lord, that is the crucial issue. It is not about uniform, my lord. And therefore, my lord, I respectfully submit that in the interim, my lord, my lord, these students have been, my lord, going to the school wearing the uniform and, my lords, wearing their headscarf. My lords, let that, my lords, situation continue. Let your lordships, my lord, take whatever time it takes, my lord, to decide this issue. In the meanwhile, my lord, it is the customary practice, lords, to wear a headscarf over the head, my lord. And there are traditions which are there all over the country, my lord, and these are innocuous traditions, my lord. It doesn't harm anybody. This is not a question of public order. This is not a dangerous practice, my lord, where this uniform, my lord, the headscarf of the same color, and let them commence going to school, my lord. And what the state, just one more submission, my lord. The state today says, my lord, I heard the learned AG saying that, look here, we have not done anything. We have only asked the school committees to take a decision. My lord, this is totally wrong. The state, my lord, is playing, my lord, by the fire, and I want to say this. In the GO, my lord, kindly see the GO. The GO has not been placed before your lordships. The GO says, my lord, kindly, if my learned friend can just give an English translation to the Honorable Court. The GO says, my lord, that the headscarf is not a part of religious practice. My lord, and then the state, and there committee. Lord, is it what the state is saying? Lord, I am making a submission. Lord, I am making a submission. The AG will not, my lord, interrupt me. Lord, we are in your lordship's hand. It's the court of law. And I hope, my lord, there is freedom of speech and expression here. Lord, just have a look at, my lord, the GO. We have made an English translation. If I can just place, I had placed this before Honorable Justice Dixit, my lord, for at length. But if I can just place this GO, my lord, this is the basis of the state's decision. Lord, if I can just skip the recitals, just have a look at, my lord, page 2. Just before the quotation, my lord. The question relating to uniform dress code over individual dressing choices has come up in several cases before the Honorable Supreme Court and High Courts. And then, my lords, one, Kerala High Court is cited. Number 2, my lords, over the page, Lord of Bombay High Court judgment is cited. Number 3, my lord, there is a Madras High Court judgment which is cited. And see the last paragraph, my lord, on this page. And this is what I was talking about, my lord. This is not as innocuous as the learned AG says, oh, we have not done anything. We have left it to the local committees. As mentioned in the aforementioned rulings of the Honorable Supreme Court and various High Court, since the prohibition of a headscarf or a garment covering the head is not a violation of Article 25. Additionally, in terms of the Karnataka Education Act, the government has decreed as below. Then, my lords, over the page, this is the order, is as far as schools are concerned.
That order is what is binding
my lord,
on authority.
my lord, I don't understand, my lord, this kind of anxiety with the learned AG. We are, my lords, making submissions. We are not on the street. I respect the AG immensely, but I think at least a little bit of that modicum of respect should come back.
I am saying,
Lord, I am making a submission. Learned AG will not interrupt.
the operating portion of the
Lord,
order.
please protect me, my lord. This is not the way
The CDC.
the AG of a state should not argue a case. Because I am making a submission. Just have a look at the order, my lords. The last paragraph. In colleges that come under the pre-university education department's jurisdiction, the uniforms mandated by the College Development Committee or the Board of Management should be worn. In the event that the management does mandate a uniform, students should wear clothes that are in the interest of unity, equality, and public order. Now, my lords, by itself, my lord, it may sound innocuous, but what precedes this order is the declaration of a law which the state is entirely incompetent to, my lords, make, that hijab or wearing a headscarf is not a part of religion. And that is why, my lord, this challenge to the GO is crucial. My lord, we are not concerned, my lord, with whether the committee has the power to do it, whether, my lord,
Mr. Kamar,
yes,
we will not consider
yes, my lord.
now this issue
Yes,
that
my lord.
as whether the wearing of headscarf
Yes, my lord.
confers any fundamental right
Yes, my lord.
under Article 25.
Yes, my lord. That's the heart of this case, my lord. That's the heart of this case. Your lordships have.
Now, that question would be considered by us.
Yes, my lord. Yes, my lord. But I am saying, my lord, since this is an issue of fundamental rights and lordships, my lord, as a constitutional court.
There's one more question which may require consideration.
Yes, my lord.
As to whether wearing of this headscarf
Yes, my lord.
is an essential part of religious practice.
Absolutely.
Essential part.
My lord,
My lord.
my lord,
Then the
on the
first fundamental right.
my lord, on the
Then
interim,
when
my
the
lord,
question of fundamental right, first
Yes.
you will have to address as to
Yes.
whether it is an essential part of the
Absolutely.
religious practice.
I,
Then,
My lord,
my lord,
then
there
question
is
comes
plenty-
under Article
there is
25.
plenty that
I'll
I
go
will
on.
place.
Lord,
There is
what I was
plenty
saying is
that I will place.
just as in any case, my lord, for the interim, lordships will have to be satisfied, my lord, that the petitioners before your lordships have a prima facie case. There is a balance of convenience. And, my lord, the third principle of irreparable injury. And what I wish to submit, my lord, that I want to make a prima facie case.
That is why Mr. Kamath
Yes, ma'am.
asked Mr. Hegde
Yes,
as to whether he taking his submission finally on the
Yes,
final date of the matter or for the interim purpose.
my lord, I was
May I answer?
I was
The question is
supposed
to
to
me.
He-
Mr.
for
Kamath,
the
the question
interim.
is to me.
Yes, my lord.
The question is to me, my lord.
I have no
And
difficulty.
I-
Mr. Hegde, thereafter I'll answer. My lord.
Please, ma'am. My lords, I do not like my arguments being anticipated on my side.
Definitely, definitely.
Please, my lords. And here, my lords, there are two parts of the argument. There is as far, and that is why I was trying to ascertain the convenience of the court. Primarily, it is this. If we go into the question of essential religious practice, I place the Quranic verses, I place the commentaries on it, and thereafter, your lordship hears Mr. Kamath, your lordship hears the Advocate General, and it goes on. I can assure your lordship that it will take time, and it will not. And if I use the phrase, it may take God's good time.
It will take time. You cannot.
It will take God's good time. But there are children, there are girl students who have a very difficult problem. It is very easy for the Advocate General to say, let them just go back. But should they, having taken a conscientious decision, freedom of conscience is also assured to every citizen, irrespective of majority or minority. Should they, in the interim, stifle their conscience and go back into school? Is that the piece that is? My lords, I have some experience of this state. I have been at standing council for 10 years. I know the
और जैसे हमारे सभी ऑडियंस यहाँ पर है तो मैं जब तक आप सबको बताता हूँ कि अब तक क्या मामला चला। ये जो एडवोकेट संजय हेगड़े हैं जो फिलहाल के लिए हिजाब की या जो ड्रेस कोड है यूनिफॉर्म के बारे में ये कर रहे हैं, हियरिंग दे रहे हैं। साथ साथ चीफ जस्टिस आपने देखा कि किस तरह से वो हैं और एडवोकेट कामत भी यहाँ पर हैं। तो अभी भी एडवोकेट कामत ने काफी करेक्ट बात कही है कि भाई हिजाब को इसमें बीच में मत लाइए, हिजाब का मामला नहीं है, ये मामला सिर्फ हेड स्कार्फ का है। यूनिफॉर्म हमारी लड़कियां पहनेंगी, क्लासरूम में यूनिफॉर्म ही पहन के बैठेंगी जो कॉलेज में दिया जाएगा। सिर्फ एक एडिशनल चीज है कि सर पर जो है स्कार्फ वो चाह रही हैं, क्योंकि ये मामले को इंटरप्रेट सही तरीके से नहीं किया जा रहा है, ये मामले को हिजाब बुर्खे की तरफ ले जाया जा रहा है। वैसा नहीं है, हमारी लड़कियां तैयार हैं यूनिफॉर्म पहनने के लिए और यूनिफॉर्म का ही कलर का जो है स्कार्फ पहनना चाह रही हैं। इसी पर मैं बात करना चाह रहा हूँ। तो चीफ जस्टिस ने भी इस पर सही क्वेश्चन किया। उन्होंने कहा कि अच्छा, क्या ये जो हेड स्कार्फ है वो मुसलमानों की एसेंशियल प्रैक्टिस में आता है क्या? जैसे कि सिख के लिए टर्बन आता है, इसी तरह से मुसलमानों के लिए हेड स्कार्फ एसेंशियल आता है क्या? उन्हें पूछा। इस पर कामत जी ने कहा कि बिल्कुल ये ऐसा ही आता है, एसेंशियल पार्ट है, ये पहनना जरूरी है। इस पर संजय हेगड़े साहब, जिसको आप स्क्रीन पर देख रहे हैं, वो ये कह रहे हैं कि ये एसेंशियल पार्ट है या नहीं, इसके लिए कई सारे कुरान के मैं रिसाइटेशन दूंगा, कई सारे हदीस के बारे में बताऊंगा, लेकिन इसको काफी टाइम लगने वाला है। अगर इसके ऊपर टाइम ज्यादा जाएगा तो बच्चों की पढ़ाई खराब हो जाएंगी, इसलिए आप कॉलेज चालू कर दीजिए और जैसे बच्चे जा रहे थे पहले यूनिफॉर्म में, वैसे ही उन लोगों को कॉलेज भेज दीजिए। ये डिसीजंस अपनी जगह आते रहेंगे, लेकिन बच्चों की एजुकेशन को आप खराब ना करें। इस तरह से संजय हेगड़े साहब कहना चाह रहे हैं। लेकिन कामत जी कहना चाह रहे हैं कि भाई टाइम तो लगने वाला है, लेकिन इंटरिम रिलीफ दीजिए और बच्चों को स्कार्फ पहनाकर आप जो है कॉलेज भेजिए। ये अब तक का जो मेरा सारा निचोड़ आपको मैंने बता दिया कि एग्जैक्टली सारा मामला क्या चल रहा है। तो बहुत टाइम लगने वाला है इसे, अगर आप लाइव देखना चाहते तो देखिए। मैं तो ये कन्वर्सेशन स्टार्ट कर दी है, इस बीच बीच में आपको इसके बारे में सारा अपडेट देते रहूंगा।
They are all our children. They are all our girl children. And this is not a case only about essential religious practice. It is a case of essential education for the girl child.
Okay.
And so, if there is a state, if there is, I will prove that there is no rule. I will prove that there is no guideline on this. However, even assuming today that there is this resolution of a college committee which reads, my lords, let me make a confession. I can't read Kannada. I'm reading Kannada from the Roman script, but I can speak Kannada. And
I can neither read nor speak.
yes, so therefore, my lords, the college requirement is ಬಿಳಿ ಬಣ್ಣ ಮತ್ತು ನೀಲಿ ಬಣ್ಣದ ಚೆಕ್ ಸ್ಟಾಪ್ ಮತ್ತು ನೀಲಿ ಬಣ್ಣದ ಪ್ಯಾಂಟಿನ ಕಲರಿನ ಭುಜದ ಮೇಲೆ ಹಾಕಿ ಕೊಡುವ ಶಾಲ್, which basically means the same color as the pants as the chudidar or the shalwar. You will have a shawl or a dupatta on your shoulders. Students, my girl children, will adhere to that. But if they tuck that same chudidar over their head, nobody should, is consistent with their faith. Nobody should have an objection. And particularly, my lord, I showed your lordships the pleadings. This is something which can be resolved at that PUC college level. A wise administration, a wise government will issue the necessary instructions. Today, your lordship may consider it. If your lordship gives a clarification that those children can go back to school, they will be wearing the uniform. How they wear the uniform or a part of the uniform consistent with their faith is up to them. Nobody should have any objection whatsoever. That is one way of sorting it out. That is one way of sorting it out in the interim, and that is the case. That's the course of wisdom, even if it is I who says so. There are very deep-rooted questions of identity here. Is it essential religious belief? I heard the Advocate General yesterday say that there are 2 verses of the Quran and there are multiple interpretations. To which my most respectful answer is, my lords, that it is my religious faith as a lawyer of this court that the Constitution of India is supreme. And there may be one article here and one article there. There may be a 14 here, there may be a 21 there. There may be multiple interpretations of what 14 and 21 are. But there can be no manner of doubt that they all come to the aid of every citizen, for the butcher and the baker and the candlestick maker, to use Justice Vivian Bose's quotation from The Owl and the Pussycat. So here, my lord, I do not wish to add any fuel to any fire. The first thing that this state needs is for the children to return to school, for peace to return, and the atmosphere of tenseness to calm down. This is a state which cannot afford any kind of disturbance. This is the state which contributes the maximum to India. I was very proud when I used to be represented in the Supreme Court to say that we probably provide more in income tax than almost per capita than almost any other state in India. This is a state which has contributed the maximum unicorns to the Indian economy. I would not want it impaired. And if a problem can be confined to a small place in an easy manner, I would request your lordship, in your wisdom, to suggest to the state and to work out something my lord, it does not, leaving it to the college development committee would, I agree with Mr. Kamath there, would not be healthy. The college development committee, the local MLA, everybody has their own calculus. I'm not saying right, wrong, or the other. They may not see the big picture. They may not have had the benefit of working so much on the law over so many years. Today, my lord, if the Advocate General of the state could be asked to do something that in a manner consistent with the dignity of everyone. After all, what is the preamble of the Constitution? What is it? After everything it says, consistent with the liberty and dignity of the individual. The question of a woman's perceived sense of identity and dignity. Of a girl child who, like in my hometown of Udupi, we had Kanakadasa, who was excluded from the Udupi Sri Krishna temple. We had the father of the Constitution, Dr. Ambedkar, when he went to school, was told to sit slightly apart on a sackcloth apart from his students. After so many years of the Constitution, after so many years of the Republic, my lords, I do not want any kind of separation. We are a country which is like no other. We are a mix of so many influences, so many kinds of people. And I explained things to my brother's mother-in-law, who's a white American, that there is one operating principle in India, which if you know, everything works. If she asked, what is that? I said, sometimes we have to kindly adjust. That one word, that's adjust, kindly adjust. That is reflected in the last words of the Supreme Court of Justice Chinappa judgment of the Supreme Court in Bijoy Emanuel Malot. Bijoy Emanuel, the last line, if your lordship just give me a minute. Is that we only wish to add, our tradition teaches tolerance, our philosophy teaches tolerance, our constitution practices tolerance. Let us not dilute. Lord, if the learned Advocate General could be asked that is there some way, and I am willing to sit with the learned Advocate General at whatever personal cost or whatever, to sort things out. But if your lordships could ask the state, why do we take unnecessary pride or whatever on, why do we stake our country on some one particular version, that this and this alone is the path? Well, we are a country, we are a civilization of multiple paths.
Well, if my learned friend has finished, then only hands. Yeah. My lord, I completely subscribe, my lord, to what my learned friend has, submitted. My lord, this suggestion had also come, my lord, from the bench when my lord's Honorable Justice Dixit was there, and this was put to the learned Advocate General. Learned Advocate General, my lord, frankly said that, my lord, nothing may be possible, and thereafter, my lord, lordship started the hearing. Even at this stage, my lord, if the learned Advocate General says something can be worked out, that, my lord, we continue to go to school wearing only a headscarf with the same color, my lord, we would be too happy, my lord, and the lordships can decide this matter, my lord, in the fullness of time. But if that is not my lord, possibility, then I would urge your lordships to kindly hear us, my lord, on the prima facie case, balance of convenience, and just give me, my lords, 15-20 minutes. I will show, my lord, that this whole geo is nothing but a sham, my lord. I can show that, my lord, in just 10 minutes. And my lord, lordships may ask the AG if something is possible. I will not argue, my lord. There's no difficulty at all. But we would all like, my lords, that the matter can be resolved at least at the interim stage without, my lords, having to trouble your lordships. But if that is not possible, my lord, I respectfully submit, my lord, that lordships will hear us on the interim relief. That's all, my lord.
In continuation with Mr. Kamath has submitted a very short submission in support of the petitioner. But this was suggested before His Lordship Mr. Dixit also. I may request, but this is more a question of attitude, at least for this interim state. Of course, we can rather argue for days and days together. All that I am submitting, if there is a correct attitude on this, if there is a correct attitude, the state is actually winning, not losing. But when
are you representing anyone?
I am in repetition civil number 2347/2022, but where I made a submission before His Lordship Justice Dixit also, His Lordship was pleased to entertain the submission. Probably I am in continuation with that. IA number 7 is the IA. I am only on a very short issue. I am not arguing the matter. I am only suggesting 1 minute will be enough. What I am suggesting is this. But if the state is benevolent enough to understand the situation, would have to take an interim measure to entertain these students with the dress, with the attire. Because why I am submitting, the Lordship knows. But we have a constitution which says 25 explanation says, but even the kirpal is permitted. But this was the submission which I was trying to make before the Justice Dixit, the kirpal. And there is a Punjab and Haryana High Court judgment. Despite the inherent danger which a kirpal may pose, this is the constitution which has accepted that. There's the Punjab and Haryana judgment on that. There's also a judgment of a foreign court. All that can submit. If they feel that this is harmless, this is not that harmful. If the dress, if the attire is not that harmful, they can take a view on this. And that's what I'm saying.
The student of University of Oxford and is not a party to the president, it's not a petitioner, etc. This application now they have filed to intervene in the matter as an intervening applicant in this petition. Obviously, they have no locus onwards as a party. If management wants to impede himself, then an application has to be filed or statement. Only then after interim process begin, we'll have one. But this will become number of subject to what
Lord, sir. So therefore,
but I do not know how.
So there doesn't seem to be much of a consensus, my lord, on an interim arrangement. So we will not waste your lordship's precious time, my lord. Just give me 20 minutes, my lord. I will demonstrate, lords, a prima facie case for grant of an interim order, my lord. Just have a look at, my lord.
Without interruption, my lord, the one IA which the learned AG was referring to is in fact IA number 6 of 2020. I think the AG is slightly getting confused between the two IAs. There are two interlocutory applications filed. One is by a Oxford University PhD student who is working and researching on discrimination.
That's all right, ma'am. That's all right, madam. Let's go on merits.
Yes.
Lords, may kindly, my lord, just bear with me, lord. Since I have heard Mr. Hegde, my lord.
No, I have not.
Just give me 15-20 minutes, my lord, on prima facie case. And my lord, thereafter, my lord, lordships will take a call because it's already 3:45, my lord. Lord, just give me 15-20 minutes. Yes, my lord. Lord, just give me 15-20 minutes, my lord, on prima facie case. My learned friend has argued on the
Our request is that all should argue one by one.
Yes,
we cannot hear the arguments in piecemeal.
Yes, I follow that. For interim, my learned friend is
then only you argue.
Yes, my learned friend.
I yielded to the Advocate General, who has a right of audience. Otherwise, the normal rule is that the court hears one petition after the other.
Very well.
And so, since I was placing the first petition, even on the prima facie a case, if your lordship comes back to my written submission.
Yes.
Because that will also make out my case on prima.
राइट, अभी जैसे कि आपने देखा कि एडवोकेट कामत 15 से 20 मिनट का टाइम मांग रहे हैं उन्हें प्राइमा फेसिया केस बताकर इसका डिसीजन लेने के लिए। साथ साथ संजय हेगड़े साहब भी यहाँ पर बता रहे हैं। तो ये सारा मामला चल रहा है। संजय हेगड़े साहब ने भी ये बात को माना है कि जो स्कूल के कॉलेज डेवलपमेंट कमेटी का जो रूल है कि भाई जो कपड़े किस तरह से पहनना है, जो आपका जो पैंट होता है, जो सलवार होता है, उसी का आपको दुपट्टा है, उस दुपट्टे को आप सर पर डालते हैं नहीं डालते हैं, ये अब आप जो है उस पर बात करें। और उन्होंने भी कहीं ना कहीं बताया है कि हेड स्कार्फ जो है एसेंशियल है, हेड स्कार्फ एसेंशियल है, लेकिन वो कह रहे हैं कि एसेंशियल जो है एजुकेशन है। फिलहाल सबसे इम्पोर्टेंट एजुकेशन जो है, एसेंशियल रिलीजियस प्रैक्टिस मत देखिए, एसेंशियल एजुकेशन देखिए। बच्चों के एजुकेशन डिस्टर्ब होते जा रहा है ऐसे मामले में आकर, इसलिए पहले एजुकेशन को आप रिज्यूम करें। तो ये देखना ये होगा कि चीफ जस्टिस आप क्या डिसीजन लेना हो। तो ये बहुत ही अनकरीब है, तो आई थिंक अनदर 20-25 मिनट के अंदर ये डिसीजन आ जाएगा।
Manoj, I have the background for this is the preliminary submission on constitutional avoidance, where the Supreme Court following.
Mr. Hegre, we have understood Carnatic Education Act do not prescribe a uniform.
Please,
there is no punishment prescribed for failure to wear a uniform. Now, so far as this submission, right to wear a hijab falls within the ambit of the right of expression guaranteed under Article 19(1)(a), and the right to privacy and also freedom of conscience under Article 25 is concerned. Do you want to elaborate?
There is an elaborate written submission in there, but my request today is simply this, that the normal rule of constitutional adjudication is that if your lordships can dispose it off on a smaller question without going in to the larger question of the hijab, then your lordships will go, will necessarily go use that, and that is what the Supreme Court has held. If your lordship sees at page 2. At page 2, I am of the opinion that a case which can be decided of without deciding constitutional questions should be so determined without expressing an opinion on the constitutional questions raised, unless absolutely necessary for the purpose of deciding the case. I do not think. Please.
That stage is not now, because already the single judge has said that these issues now involve important constitutional issues which require to be determined by the larger bench. So now you are before the larger bench. So now these are the constitutional issues which are required to be considered. So we cannot say that without referring to the constitutional issues, we can decide the matter. What we prima facie feel is that stage is now over.
Please, man.
If the matter has come up before the larger bench.
The second submission. Please, Manoj. Manoj, may I request my learned friend, Mr. Tahir, to give the second set of submissions on the larger. I had separately put it in two separate headings, one on the smaller, one on the larger. Mr. Tahir, I can't make out whether he's in the I'll wait. That's my Lord. Yes. Please, ma'am. In the Court in National Legal Services Authority, 2014 5 SCC 438 has recognized that clothing and appearance fall within the ambit of the right of expression guaranteed under Article 19(1)(a) of the Constitution. In Jigya Yadav was CBSE 2021 7 SCC, the court was dealing with CBSE bylaws that restricted a student from changing his name in the records. Para 125 thereof, I have put in all the passages for you. Identity, therefore, is an amalgam of various internal and external, including acquired characteristics of an individual, and name can be regarded as one of the foremost indicators of identity. And therefore, an individual must be in complete control of her name, and law must enable her to retain as well as exercise such control freely for all time. Such control would inevitably infuse the aspiration of an individual to be recognized by a different name for a just cause. 19(1)(a) of the Constitution provides for a guaranteed right to freedom of speech. In the light of now Johar, this freedom would include the freedom to lawfully express one's identity in the manner of their liking. In other words, expression of identity is a protected element of freedom of expression under the Constitution. In this case, wearing of a hijab is an expression of religious identity. The same is a right protected under 19(1)(a) of the Constitution. It can only be curtailed by way of reasonable restrictions under the grounds mentioned in 19(2). None of the grounds are made out in this case. It's also relevant to submit that the state has a positive obligation on the state to create and maintain conditions in which the freedoms guaranteed by the Constitution can be exercised. In the state of West Bengal case, the court held the freedoms which are guaranteed by 19 are universal. 19(1)(a) stipulates that all citizens shall have the freedoms which it recognizes. Political freedoms impose a restricting influence of the state by carving out an area in which the states are not interfering. Hence, these freedoms are perceived to impose obligations of a restraint on the state. But apart from imposing negative restraints on the state, these freedoms impose a positive mandate as well. In its capacity as a public authority enforcing the rule of law, the state must ensure that conditions in which those freedoms flourish are maintained. In the space reserved for the free exercise of speech and expression, the state cannot look askance when organized interests threaten the existence of freedom. The state is duty-bound to ensure the prevalence of conditions in which those freedoms can be exercised. The instruments of the state must be utilized to effectuate the exercise of freedom. When organized interests threaten the properties of theatre owners or the viewing audience in reprisals, it is the plain duty of the state to ensure that speech is not silenced by fear of the mob. Unless we were to read a positive obligation on the state to create and maintain conditions in which freedoms guaranteed by the Constitution can be exercised, there is a real danger that art and literature would become victims of intolerance. In the present case, we are of the view there has been an unconstitutional attempt to invade the fundamental rights of the producers, the actors, and the audience. My lord, then, if I may skip over the rest of that passage, if your lordship permits the next one, the right to privacy, the freedom of conscience, and the right to practice, profess, and propagate religion are explicitly recognized under Article 25. The Supreme Court also recognized the freedom of conscience to be part of the rights to privacy. In Puttaswamy, the court observed, while the right to freely, this is para 372, while the right to freely profess, practice, and propagate religion may be a facet of free speech guaranteed under 19(1)(a), the freedom of the belief or faith in any religion is a matter of conscience falling within the zone of purely private thought process and is an aspect of liberty. In the specific context of appearance and clothing, the court observed, the choice of appearance and apparel are also aspects of the right of privacy. The freedom of certain groups of subjects to determine their appearance and apparel, such as keeping long hair and wearing a turban, are protected not as a part of the right to privacy, but as a part of their religious belief. Such a freedom need not be necessarily based on religious beliefs following under Article 35. These are from the opinion of Justice Chelameshwar. Once it is established that the freedom of conscience forms a part of the right of privacy, any infringement thereof has to be tested on the touchstone of the triple test laid down in Putaswamy at paragraph 3 and 10 and reiterated in the 5-judge judgment of Putaswamy. To constitute a valid infringement of privacy, there must be A, an existence of a law. And that's why in my earlier submission that there is no law. B, a legitimate state interest. C, that the law must be proportional. In this case, neither the 1983 Act nor the 95 rules prescribe a uniform or prohibit the wearing of a hijab. Thus, the first requisite, that is the existence of a law, is not met. Then my submissions under 25 are that 25 of the Constitution confers two distinct fundamental rights. One is the freedom of conscience. Second is the free profession, practice, and propagation of the religion. The right under Article 25 is made subject to public order, morality, health, and other fundamental rights. Article 25 rights are conferred upon communities as well as individuals. The vast majority of cases adjudicated by constitutional courts deal with the second aspect of 25, that is free profession and practice and propagation of religion. These cases have broadly involved the determination of practices that can be understood as a group or community practice. This court, the Supreme Court has held that only an essential religious practice is protected under Article 25. My Lord, while arguing before Justice Judicial, I mentioned that that too was a great case which came out of the same town of Udupi, my hometown. That was in the Sherwood Mutt case, where the Supreme Court first said, it propounded that yes, what is protected under Article 25 is the essential religious practice. In this case, the petitioners claim the right to wear hijab on the basis of their individual freedom of conscience as well as on their right to religion. The lead judgment on the freedom of conscience is Biju Emmanuel, which is 86.3 SCC, which dealt with the issue without going into the question of essential religious practice. It ultimately held that we are satisfied. May I request here that your Lordship kindly turn to the judgment of Biju Emmanuel itself, which is there in the compilation, which may have been handed over to your Lordship. 203. I do it for a particular purpose. Because the facts in Biju Emmanuel are strangely somewhat like the facts of what happened here. Fact 207 members of the compilation. 203. It starts at 203 and is at 207.
Okay. मैं भेज दे रहा, मैं भेजता ना, शादी भी बोला मैं, शादी भी रखे नहीं भेजे वो तो गया था, चार दिन उठाने पड़े थे, उठाने देखो मैं जस्ट दे क्या okay.
The three child appellants, Biju, Binumol, and Bindu Emmanuel, are faithful of Jehovah's Witnesses. They attend school. During the morning assembly, when the national anthem is sung, they stand respectfully, but they do not sing. They do not sing because, according to them, it is against the tenets of their religious faith. Not the words or the thoughts of the anthem, but the singing of it. This day, and before them, their elder sisters who attended the same school earlier have done all these several years. No one bothered, no one worried, no one thought it disrespectful or unpatriotic. The children were left in peace and to their beliefs. This was until July 1985 when some patriotic gentleman took notice. The gentleman thought it was unpatriotic of the children not to sing the national anthem. He happened to be a member of the Legislative Assembly. My lords, I read my pleadings, and here also, my lords, ultimately, constitutional rights, constitutional beliefs cannot necessarily be led to the adjudication of politicians, whether they happen to be members of parliament or members of the Legislative Assembly. Ultimately, it is the Constitution that protects all citizens, irrespective of whether they happen to be in power or out of power, elected or unelected. So, Lords, after these facts, if your Lordship, before I've placed the conclusion at page at paragraph 25, but there I would also want to place before your Lordship para 90, which I think is important. Para 90 is at page 214. May I read this? My Lord, I have all my Lords got it, please. Para 19. We see that the right to freedom of conscience and freely to profess, practice, and propagate religion guaranteed by Article 25 is subject to public order, morality, and health, other provisions of Part 3 of the Constitution. Any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice, or B, providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all sections and classes of Hindus. Thus, while on the one hand, Article 25(1) expressly subjects the rights guaranteed by it to public order, morality, and to the other provisions of Part 3 on the other hand, the state is given the liberty to make a law to regulate or restrict economic, financial, political, or other secular activity which may be associated with religious practice, and to provide for social welfare and reform, even if such regulation, restriction, or provision affects the right guaranteed to them by 25(1). Therefore, whenever the fundamental right, freedom of conscience, and to profess, practice, and propagate religion is invoked, the act complained of as offending the fundamental right must be examined to discover whether such act is to protect public order, morality, and health, whether it is to give effect to other provisions of Part 3, or whether it is authorized by a law made to regulate or restrict any economic, financial, political, or secular activity which may be associated with religious practice, or to provide for social welfare and reforms. It's the duty and function to do so. Here again, as mentioned in connection with Articles 19(2) to 6, it must be a law having force of a statute and not a mere executive or a departmental instruction. Here, my lords, Shirur Mutt is quoted, the portion from Lathan, and then what is religion is also quoted, my lords, at paragraph 20. My lords, there is also one passage at paragraph 22, which probably reflects what the dilemmas that the Advocate General and the government are facing. In the middle of paragraph 22, Justice Jackson referred to Lincoln's famous dilemma. Must a government of necessity be too, and the emphasis on strong, for the liberties of its people, or too weak to maintain its own existence? And added, it may be doubted whether Mr. Lincoln would have thought that the strength of government to maintain itself would be impressively vindicated by our confirming power of the state to expel a handful of children from school. Such oversimplification, so handy in political debate, often lacks the precision necessary to postulate judicial reasoning. If validly applied to this problem, the utterance cited would resolve every issue of power in favor of those in authority and require us to override every liberty thought to weaken or delay execution of their policies. Governments of limited power need not be anemic government. Assurance that rights are secure tends to diminish fear and jealousy of strong government, and by making us feel safe to live under it, makes for its better support. Without promise of a limiting Bill of Rights, it is doubtful if our Constitution could have mustered enough strength to enable its ratification. To enforce those rights today is not to choose weak government over strong government. It is only to adhere as a means of strength to individual freedom of mind in preference to officially disciplined uniformity, for which history indicates a disappointing and disastrous end. Justice Jackson ended further below. Justice Jackson ended his opinion with the statement: if there is any fixed star in a constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. We think the action of local authorities in compelling the flag salute and pledge transcends constitutional limitations on their power and invades the sphere of the intellect and the spirit, which is the purpose of the First Amendment to our Constitution, to reserve from all official control. And so, thereafter, I've already placed para 25, Malon, and that last sentence at para 27. So, Malon, now my comment at para 10 of my written submission. It is clear from the above that the issue as formulated by the court was not whether refusal to sing the national anthem was an essential religious practice to Jehovah's Witnesses. Rather, the issue was whether the person claiming a religious exemption was doing it on the basis of their bona fide faith. Malon, then, assuming that the essential religious practice test applies, the wearing of a hijab is essential to the Islamic faith as far as women are concerned. And the High Court judgments have been set out, Malon. The first is the 2015 judgment, where the single judge observed it cannot be ignored that in our country, with its varied and diverse religions and customs, it cannot be insisted that a particular dress code be followed, failing which a student will be prohibited from sitting for the exams. It directed that at the two centers indicated in the writ petition, the invigilator, along with a woman invigilator or other authorized officer, shall be present half an hour before the examination commences. The petitioner who intends to wear a dress according to their religious custom, but contrary to the dress code, shall present themselves before the invigilator half an hour before the exam, and on any suspicion being expressed by the invigilator, shall subject themselves to any acceptable mode of personal examination as decided by the invigilator, but however carried on by an authorized person of the same sex. If the invigilator removes the headscarf or full state garment should be removed and examined, the petitioner shall subject themselves to that by an authorized person. It's desirable that the CBSE issues general instructions. It came up again before another single judge, and Justice Muhammad Mushtaq considered the place of hijab under Islamic law, and in paragraphs 20 to 29, since it has placed extensively by Mr. Kamath, and then at para 30, the discussions as above would show that covering the head and wearing a long sleeve dress by women has been treated as an essential part of the Islamic religion. It follows a fortiori that Article 25(1) protects such. Please. Please, madam. And then there was a balancing done by the court at para 36. The court, taking note of the practical difficulty of the board for the conduct of the exam, provided sufficient safeguards. The court was of the view that the same can be followed for this year as well, and board can take necessary steps for the next year onwards by inviting application itself to protect such rights. It is to be noted, practical difficulty cannot be an excuse to dishonor the fundamental rights. Therefore, this court is of the view that for this year, the board shall permit all candidates based on religious practice want to wear the headscarf and full dress to appear for the exam. This court need not interfere with the dress code description as referred in the prospectus, as others are bound by such description, except to hold that the dress code as above shall not be enforced against the candidates who, by virtue of Article 25, are protected from wearing such dress as prescribed in the injunctions of the case. The repetitions were accordingly allowed. The CBSE appealed the decision to a division bench. However, by the time the matter was heard, the CBSE had issued a note. Besides, para 15 minutes, besides the fact that the wearing of hijab has been found to be an essential religious practice, one other aspect is the court in those cases was dealing with a temporary prohibition. The temporary prohibition was that during exams do not wear the hijab. Because sometimes these days with modern technology, with Bluetooth, with whatnot, a hijab might be useful. For that purpose alone, even there where there was a prescription, the court said, okay, this is how we balance it. Come half an hour earlier, make arrangements so that if anybody wants to check you with it, it can. The other judgment that the learned advocate general had also pointed out was in Malut's, I have stated in paragraph 16, but that, however, was a private school and perhaps also Christian minority institutions. And when the balancing happened there in para 17, the petitioners cannot seek imposition of the individual right as against the larger right of the institution. It is for the institution to decide whether the petitioners can be permitted to attend the classes with the headscarf and full-sleeve shirt. It is purely within the domain of the institution to decide. The court cannot direct the institution to consider such a request. This judgment may, if I were to distinguish on facts, private institution, minority institution, and the court was balancing two fundamental rights. As against this, in the facts of our case, this is a government institution which belongs to every citizen, or every inhabitant of Karnataka to every citizen of India. There are all kinds of inhabitants, there are all kinds of citizens. Now, can you, by a rule, make for a set of citizens or inhabitants that you may have to forsake an essential tenet of your faith at the time that you attend the institution? If you say that, then where is the overweening state interest that this alone will be done? That you will attend in this manner alone and in no other manner. Where does it satisfy the triple test which has been laid down in protocol? There is nothing. And therefore, what your lordship is called upon, even at the interim stage, is to find the right balance. And as has been submitted, my lords, here there's a prima facie case. There is also the balance of convenience in my favor, that denial of the right to attend the college would have irreversible consequences. I would implore my lords not only as far as the education of these children are concerned, everybody, in the interest of everybody's education, to find the right balance. And before I go, one thing I wanted to point out, that there are specific provisions in various central enactments which actually permit face coverings. If your lordship sees, section 129 of the Motor Vehicles Act, there, I'm sorry, it's not for face covering. It's not for face covering. 129 of the Motor Vehicles Act provides that the provision shall not apply to a person who is a thief if he is while driving or riding on the motorcycle wearing a turban. So you don't need a helmet. Similarly, in the Supreme Court rules, there are rules specifically made for the benefit of Pardanashi in women. Order 9, Rule 8, which says that when the deponent is a Pardanashi lady, she shall affirm or take oath before a lady registrar of the court, which shall include an additional registrar duly authorized. So the provisions, there are provisions which specifically authorize. Today the provisions do not specifically take away, but in practice are being so implemented in this institution so as to effectively render it nugate. It could be clarified to the institution. If the Advocate General says that it can be done on the state aspect, your lordships may consider the weight of it. Otherwise, your lordships would be required to pass interim orders, my lords, and I submit that in this case there should be interim orders which would protect the right of these students, and particularly so as far as these petitions are concerned, it's a question of 2 or 3 more months of attendance. My lords, I am very grateful for a very patient hearing.
Thank you. May it please, my lord. My lords, I beg to appear, my lord, in WP 2880 of 2022, and I will be very brief, my lord, and I will concise, my lord, my arguments only for the purposes of, my lord, interim relief, which your lordships may kindly consider.
You are appearing in 4347.
No, my lords, 2880 of 2022, Miss Aishat Shifa versus State, my lord. My lord, I will not trouble your lordships with the facts. My learned friend, my lord, has taken your lordship through some of the facts which arose in his case. But the only fact which I want to mention, my lord, which we have said in our writ petition, is that these are students, my lord, who were wearing a headscarf and going to college for the last 2 years. They are, my lords, 12th standard students. For the last 2 years, my lord, they were wearing a headscarf and going to college. Till, my lords, 3rd of February, they were stopped and said that unless you remove the headscarf, you cannot go in. But apart from those facts, my lords, I don't want to trouble your lordships with the facts. My lords, my case for an interim relief today is based on 3, my lords, broad considerations. Number 1, my lords, I want to satisfy your lordships that this GO which has been issued on 5th of February 2022, firstly, my lord, suffers from a total non-application of mine. And I'll just make that good, my lord, by taking your lordships to the GO. And that will be my first ground, my lord. The second ground, my lord, wearing a headscarf, my lord.
Yes, government order is
Yes, my lord. Yes, my lord, I'm grateful, my lord. My lords may kindly have
translation which you had
That's right.
Right.
That's right. The Kannada version is there in the writ petition, my lord, at page 20. Yes, my lord. If I can just, my lord, place the GO itself, my lord, kindly turn to page 2, which I had just read, my lord, in my opening. The paragraph 3, the question relating to a uniform dress code over individual dressing choices has come up in several cases before the Honorable Supreme Court and High Court. And my lord, 3 decisions are cited, 1, 2, and 3 over the page, and a conclusion is drawn. Kindly see the next page. My lord. The conclusion is drawn that these 3 judgments say that hijab or a headscarf is not a part of Article 25. And that, my lord, I respectfully submit, is a result of a total non-application of mind, because these 3 judgments don't say that at all. Not the entire basis of this GO is High Courts have held that this hijab is not a part of Article 25. And I will prima facie demonstrate, my lord, that this is not so. If your lordships can have the compilation which I had, my lord, given to the Honorable Court. Lords, this is a compilation. I request Shaul to kindly hand over the compilation to volume 1 to the Honorable Court. And I'll show, my lord, all these 3 decisions are totally, my lords, against the state. Just, my lord, if I can just place those decisions quickly, my lord. If my learned friend can just hand it over to the court master to give it to the Honorable Court. Volume 1, yes.
Their understanding, what you have on that. Their understanding which they have.
Yes, yes, my lord. That's right, my lord. I am saying, my lord, I am saying that understanding is totally incorrect, my lord. That's for your lordships to, my lords, Lord, decide. And I'll show that, my lord.
Thing is that come to the operative portion of the government order.
Yes, my lord. I am saying
how it affects. How
the reason is this, right? If the decision, my lord, at the penultimate paragraph, that, my lord, there is no prohibition of, my lord, Article 25 as far as wearing a headscarf is concerned. If that goes, my lord, this is totally innocuous. This is, my lord, you deal a body blow.
It is come to the operative portion. What
I go down. I am saying,
the institutions or the persons on whom this is binding, they have to go by the operative portion of the government order.
But they will also be guided.
The government order says.
Yes, Lord. I am extremely grateful for that question, Manoj. They will also be guided.
The foundation for this.
Yes.
That all those what has been earlier said.
Yes.
It may not have been said.
Lordships may
be a foundation for this. Yeah. Whatever the operative portion says.
Yes, Lord. But ultimately the building is built on the foundation, my lord. The foundation is this. Foundation is that prohibition of headscarf is not a violation of Article 25. And it's an enabling provision, my lord, for the colleges to now say, and which they are saying, my lord, that look here, you can't wear a headscarf. I am saying if the foundation goes, my lord, the building can't stand. So therefore, my lord, the foundation itself is totally questionable, is what I am saying. Now kindly see these 3 judgments, my lord, which the state relies upon. And then, my lord, I'll just make that good. The first judgment, my lord, which the state relies upon, is, my lord, a ruling of a writ petition 35923. My lords, that your lordships will please find at page 39 of this compilation.
39.
Yes, my lord.
Yes.
Totally, my lords, inapplicable to the facts of this case. Just have a look at page 39. Religious dress. I'm sorry, my lord.
Yes.
My lord has page 39, my lord.
Yes, page 39 of your compilation.
Yes, my lord. Religious dress in a private educational institution is an issue in this writ petition. My lord, the Chief Justice.
No, the compilation which you have passed on.
Lord, 839, this compilation, my lord, starts with Fatima Hussain, my lord.
It is not on this.
Lord, I don't know, volume 1, which we handed over to the Honorable Learned Single Judge, my lord.
Which has been given to us is volume 2.
No, volume 1. I'm sorry, I think they have made a mistake, my lord. I'm so sorry, my lord. Volume 1, I was requesting. I'm so sorry, my lord, to waste the lordship's time. Whether it is
not virtual. It is not virtual. We are in hybrid mode.
Yes, I'm sorry, since I am yes, since I am addressing the lordship, yes, I am at a handicap, that's why I'm not assisting a lordship. What may kindly have changed the choice that you are appearing by.
पढ़ रहे हैं, हालांकि उनके एसेंशियल रिलीजियस में आता है कि नहीं पढ़ना चाहिए, तो फिर भी पढ़ रहे हैं, तो ये भी जो है एसेंशियल चीज है, तो क्योंकि आपको सोसाइटी में रहना है, तो आप क्यों नहीं इसे फॉलो करते? इस तरह का कहीं ना कहीं एक स्टेटमेंट लेकर उन्होंने, जितना मुझे समझ में आया है, आई थिंक उन्होंने कहा है, लेकिन कामा सर अभी भी कह रहे हैं कि रिलीजियस प्रैक्टिस, एसेंशियल रिलीजियस प्रैक्टिस में हेडस्कार्फ आता है, बच्चियां स्कूल यूनिफॉर्म पहने रेडी हैं, क्लासरूम में जाने रेडी हैं, बुर्खा पहन के वो कैंपस तक आएंगी, क्लासरूम में बुर्खा उतारेंगी और सिर्फ हेडस्कार्फ पहनेंगी। अब देखते हैं कि चीफ जस्टिस का क्या जवाब देते हैं।
To have the choice of dress based on religious injunctions is a fundamental right protected under Article 25, when such prescription of dress is an essential part of religion. Therefore, there may not be any difficulty to hold that it is the fundamental right of the petitioners to choose the dress of their own choice. Then, my lords, paragraph 5, my lord, that is the Article 30 right is discussed, that is of a minority institution. And then, my lord, may turn over the page. Paragraph 10, my lord, page 41.
Come to paragraph 7.
7, my lord, I'll read it now. Fundamental rights are either in the nature of the absolute right or relative right. Absolute rights are non-negotiable. Relative rights are always subject to restriction imposed by the Constitution. The religious rights are relative rights. In the absence of any restriction placed by the state, the court need not examine the matter in the light of the restriction under the Constitution. The court will therefore have to examine the matter on a totally different angle on the conflict between fundamental rights available to both. The court has to examine the prioritization of fundamental rights in a larger legal principle on the legal system function in the absence of any constitutional guidance in this regard. The Constitution itself envisages society where rights are balanced to subserve the larger interest of society. So, my lord, in the context of Article 30, the court says you have to balance the fundamental rights. So, what you
they have considered this judgment.
Yes.
A larger public interest.
Yes, my lord.
While issuing this government order.
Yes, my lord.
They have to balance. They have to balance the rights of both the educational institution and the individual religious rights.
Correct, my lord.
Now, considering this judgment, what is wrong?
No, my lords. What I'm saying is this. This decision, my lord, was in the context of a private minority institution which has Article 30 right. Right, my lord? Now, the same learned judge, my lord, when it comes to a government institution, please see his approach. And that is why I just wanted to place, my lord, page 24.
We are not here to judge the approach of the judge individual.
Yes,
that is not for us to see.
No, I kindly see, Lord, what has been held, because that will probably assist the Lord.
You said that they have totally non-application of mind.
Yes,
considered judgments.
Yes,
which have been referred in the government order.
Yes, Lord.
Now we have pointed out the paragraph 7 of the judgment to you to show that in order to balance, to subserve the larger interest of the society, they have, if you consider this government order, what wrong they have done.
I go down. That's a very important question which your lordship is posing me. But this decision, my lord, was in the context of a private minority educational institution which has a separate set of fundamental rights, my lord, under Article 30 of the Constitution. I'm not lordships are very well aware, my lord. So therefore,
private education institutions are also under the Constitution.
Go down, my lord. I go down.
Only thing is that they have got some additional right
Yes.
to manage the institution under Article 30.
And my lords, their right, my lord, to admit students of their choice is totally unfettered.
It does not mean that the general law will not apply to them.
I go down, my lord. I go down. Now, my lords, kindly see what happens in the context of a government institution. Just see, my lords, page 24, if your lordships permit. Page 24. So the first decision which I showed, my lord, is in the context of a minority institution, which according to us, my lord, is totally inapplicable as far as government institutions are concerned. So that is the point of distinguishing, my lord, which I wanted to place for my lord's consideration. In the context of a government order, government institution, please see what happens at page 24, my lord. Page 24 of this very compilation.
That is where in this CBSE examination,
that's right, my lord. Where, my lord, the learned judge examines, my lord,
but this is the subsequent judgment.
Yes, no, the subsequent judgment, my lord, notes that the general principle which is applicable in respect of government institution will not apply to private educational institutions. And that does not, my lord, the private minority institutions, my lord, in that case, there is no discussion on, my lords, whether it is an essential religious practice or not. Now, just if your lordship had this judgment, just turn to, my lords, page 29, if your lordships don't mind, my lord. Page 29. My lords, in this particular judgment, the core issue which is there before your lordships as to whether wearing a headscarf, my lord, is a part of, lord, essential religious practice was squarely gone into. Not in the other judgment, my lord, which your lordship just saw. Now see page 29, para 17. Coming back to the core issue in this writ petition about the dress code, it is to be noted that Islam embraces and encompasses guidance to human will, so and so. Then, my lords, what are the sources of Islamic law are noted. And eventually, my lord, kindly see para 24, my lord. After discussing the sources of Islamic law, including the Holy Quran, the court comes to a conclusion. My lords, in paragraph 29, my lords, I'll avoid other things. Para 29, my lord. I'm sorry, page 32. Page 32, para 29. So my time is limited, my lord. I'll just show the conclusions only. Thus, the analysis of the Quranic injunctions. My lord, the Chief Justice got para 29. Yes. Thus, the analysis of the Quranic injunctions and the hadiths would show that it is a farz to cover the head and wear the long sleeve dress except face part and exposing the body otherwise is forbidden. When farz is violated by any action opposite to farz, that action becomes forbidden. However, there is a possibility of different views or opinions, which the AG was referring to yesterday. This court is not discarding such views. The possibility of having different propositions is not a ground to deny the freedom. If such propositions have some foundation in the claim, as has been adverted below, the claim of the petitioners is well founded, even though a different view is possible. So, Lords, even if a different view is possible, the court says, if, my lord, it is the believer's faith, then, my lord, the courts have to yield to it, and that flows, my lord, from the Supreme Court judgments as well. Now, my lord, ultimately the court said that this is a facet of essential part of religion. Now, my lord, the second judgment, which the GO relies upon, is, my lord, a decision of the Bombay High Court, which your lordships will find, my lord, in the compilation itself, which is the first judgment, my lord, in the compilation. And this judgment, my lord, it's the first one in the compilation. Page 1, my lord. Page 1, my lord. The judgment starts. And see, my lords, page 2, the conclusion. Para 7, Justice Lodha's judgment, very, my lords, beautifully put. And how it is limited, my lord. Kindly see, my lord, page 2. A girl student, para 7, my lord, page 2. Yes, sir. A girl student not wearing a headscarf or head covering studying in exclusive girls section. Kindly see this, my lord. Kindly make a note, which I am recommending for your lordship's kind consideration. A girl not wearing a headscarf or head covering studying in exclusive girls section cannot be said to in any manner acting inconsistent with the aforesaid verse 31 or vitiating any injunction provided by the Holy Quran. So, my lord, this was in the context of an all-girls school. So, therefore, my lord, in a matter of co-education, this judgment is totally inapplicable. And I will just place 1 or 2 verses of the Holy Quran, my lord, because that is the, my lord, primary source of Muslim law as per Mullah, my lord, after this. Now, my lord, this judgment is not applicable. The third judgment, my lord, which the GO relies upon, is a Madras High Court judgment. And that judgment, my lord, doesn't deal with Article 25 at all. That was a case, my lord, where the teachers were asked to wear a uniform, and, my lords, under the provisions of the Tamil Nadu Education Act, whether the teachers could wear a uniform or not, that was the issue. Not even one word, my lord, about Article 25. That judgment your lordships will find, my lords, which is at page 4, my lord. I will not trouble your lordships of this very compilation. Lordships will see that judgment, page 4. My lords, there is not even one word, my lord, in the entire judgment about wearing of a headscarf or anything about Article 25. This was about prescription of my lords, a prescription of a dress to teachers. In that context, my lord, what are the provisions? What is the contract between the teachers and the government, my lord? That was an issue. Nothing to do with Article 25. And the government says, my lord, these 3 judgments are authority to say headscarf, my lord, is not a part of essential religious practice under Article 25, which I say, my lord, is a total affront to, my lords, the freedom which is guaranteed under Article 25. Now, my lords, just on this, my lords, I just want to cite 1 or 2 things on Article 25. Because I have also prepared a brief note, my lord, which has all my submissions for the purpose of interim relief. If I can request, my lord, my learned friend, to just hand over that note. Because your lordships will not be troubled, my lords, by going through this judgment and that judgment. I have quoted everything. In fact, my lord, the Honorable Justice Dixit had asked me to prepare a written note. I have prepared, my lord, for that purposes. So I have, my lords, put everything at one place. So your lordship, my lord, has the benefit of seeing everything at once, my lord. If I can just request, my lord, my learned friend, to hand over that note. My lords, kindly see first page 3, my lord, of this note. What is the, my lords, essential practice? And I'll demonstrate. We don't have to go, my lord, to any subsidiary sources of Islamic law. Just have a look at page 3, my lord. What is the relevant verse of the Holy Quran? Page 3, my lord. My lords, if I can just place for my lord's consideration, verse 24:31, which I have reproduced in paragraph 7, and tell believing women that they should lower their glances, guard their private parts, and not display their charms beyond what is acceptable to reveal. They should let their headscarves fall to cover their necklines and not reveal their charms except to their husbands, their fathers, their husbands' fathers, their sons, their husbands' sons, their brothers' sons, their sisters' sons, their women folk, their slaves, such men as attend to them who have no so and so, or children who are not aware of women's. So, my lord, the prescription of headscarf is specifically prescribed in the Holy Quran. 24.31, my lords, I am placing for my lord's consideration. And my lords, verse 59, I have quoted over the page. My lords, apart from the learned single judge, which I have shown, my lord, who has gone into this, the Kerala High Court, and has said that this is essential practice of religion, there is a division bench of the Madras High Court, my lords, which I have placed in paragraph, my lords, 12, if your lordships just sees, my lord, over the page. Paragraph 12, my lords, page 5. I have cited all these other decisions, my lord. I don't want to trouble your lordships, but just see page 5, para 12. This is Ajmal Khan, my lord, and this is there in the compilation. Lordships will see that I have given the reference to the compilation page numbers also, and I have extracted, my lord, what the relevant portion is. And if I can just, my lord, invite your lordship's attention to the relevant portion, which is highlighted in paragraph 15. It is thus seen from the reported material that, I'm sorry, my lord, the Chief Justice got it, para 12, my lord, I'm so sorry, my lord. Para 12, my lord. Yes, my lord. Para 12, division bench, my lord, of the Madras High Court. It is thus seen from reported material that there is almost unanimity amongst Muslim scholars that parda is not essential, but covering of headscarf is obligatory, my lord. So, my lord, we have an authoritative judicial, my lord's, determination on, my lord's, Islamic law, of course, of a different high court, which for the purpose of prima facie, my lord's, case, which I am placing for my lord's consideration. Then, my lords, B.J. Emmanuel was read to your lordships in detail. I am only placing, my lord, one portion of B.J. Emmanuel, which says, my lord, that what is an essential practice, my lord, is not to be seen from my standpoint or, my lords, anybody else's third party standpoint. And, my lord, we have to see it from the, my lord's, perspective of the believer. My lords, as an officer of the court, my lord, and as an individual, I may completely disagree, my lord, that headscarf should be made, my lords, anybody should insist on a headscarf. But my opinion really doesn't matter, my lord. Because ultimately, my lord, we are talking about people's fundamental rights and are in a right-based society, my lord, to say that they will not be permitted. My lord, I respectfully feel, my lord, that in a matter of where your lordships is considering interim relief, your lordships will lean in favor of a situation, my lords, where people, my lord, can exercise their fundamental rights. In that context, my lord, kindly see page 6. The quotation, my lord, from B.J. Emmanuel. If this is the belief of the community, and it is proved undoubtedly to be the belief of the Zoroastrian community, a secular judge is bound to accept that belief, and it is not for him to sit in judgment on that belief that he has no right to interfere. And then, my lord, the highlighted portion, we do endorse the view suggested by Justice Davar that question is not whether a particular religious belief or practice appeals to our reason or sentiment, but whether the belief is genuinely and conscientiously held as a part of profession or practice of religion. I respectfully submit, my lord, at this interim stage, my lord, that there is a host of judicial, my lord, pronouncement which is available. I am not requesting the lordships to only rely upon, my lord, certain verses of the Quran. I am saying those verses of the Quran have been judicially interpreted to mean that as far as headscarf is concerned, it is, my lord, that it's a part of their essential religious practice.
What we find is that we are at the end of the day.
I
continue arguments.
Yes,
Yes, we'll have it at. We'll have it on Monday.
Lords, I was only requesting.
The thing is that we will request.
Yes,
We'll not only request, we will pass an order.
Yes, Lord.
That let the institutions start.
Yes, Lord.
Direct that institutions shall start, but till the matter is pending and consideration before the court, these students and all the stakeholders, they shall not insist for wearing any religious garment, maybe a headdress or saffron fatwa or anything, that we will restrain everyone, because we want the peace and tranquility in the state.
Lord, sir,
and only then after the matter is before the court, we are not seized with the matter. We can continue the hearing on day-to-day basis also, and we are ready to decide the issues at the earliest. But the thing is that the peace and tranquility must be restored to the state.
Lord, so may I answer that?
This is what we find, that till the disposal of the matters, you people should not insist for wearing all these religious things which are not conducive to the.
Lord, sir, may I submit, my Lord?
I am required to wear a dupatta. I am required to wear a dupatta. How they wear it?
Yes,
let them not.
Lord, may I just respond to that, my Lord? No, what your lordships are saying, my Lord, as an officer of the court, my Lord, I respectfully submit, my Lord, that would amount to a suspension, my Lord, of Article 25 as far as the students are concerned.
Whatever it is, you may take it.
But
the thing is that if you want us to decide these issues,
yes,
we also find it of some constitutional importance.
Yes, my Lord. Yes, my
Lord. Then you will have to cooperate.
Lord,
you will have to cooperate.
Lord, my cooperation, Lord, kindly see, my Lord, we are being asked to choose between food and water. My Lord, kindly see, both are essential.
No, it is not a matter of.
Please don't, my Lord, mistake us. We are asked to choose between education and our conscience. Please don't, my Lord, I respectfully submit, Lord, these are matters of moment. Lord, this is not
you
a
have
matter
approached the court, you have a faith on the court.
Absolutely, my Lord. There is no doubt.
Yes, then wait for some time.
Yes,
wait for some time.
Lord, I am just saying, my Lord, I am just saying, my Lord, your lordships are completely, my Lord, we are in the lordship.
Yes, we will pass the order.
As far as interim orders are concerned, kindly note my submissions, my Lord.
Yeah, in the midst of the argument,
yes,
we will hear you on the interim order.
I go down, my Lord. Lord, kindly note my submission that if your lordship, my Lord, direct that these students have to go without their headscarf, my Lord, that would be a total affront to their rights, because your lordships have not determined whether they have a right or not. Today I have demonstrated.
It is a matter of few days only. Mr. Kamath, please try to understand the situation.
Yes,
it is a matter of few days only.
My Lord,
I think with respect, my Lord, maybe a few days.
Yes, my Lord.
My Lord, that's the problem. Few days,
just 10 seconds.
I can't suspend my faith.
Yes. My Lord, just 10 seconds, then lordship will kindly record.
What we might want, all right, we will pass the order. We are not asking for you
to pass the order, but please record my my Lord's objection that this kind of an order, my Lord, at this stage cannot be passed. But if you record my objection, that's my only submission, my Lord.
Lord, may I
record my objection?
Lord, may I excuse with the matter, we will restrain everyone from adopting all these practices.
Yes.
Malad, may I make one request, Malad? I appeal for the petitioner in WP 2347, Malad.
We will hear everyone on the next date.
Yeah, when submission, Milord. So one more petition is connected with Milord, that has to be connected 3148 of 2022.
Yes, somebody is speaking, we cannot hear.
Maybe dividing some of still a mediation to the compromise. I found the politicians even Modi sir इतना बोल रहे हैं मैं इतना किया तो किस क्यों नहीं आ सकते गवर्नमेंट आपके सबको गवर्नमेंट क्यों नहीं कर सकते नहीं कर सकते
all right
अरे भी नहीं पेंच आएंगे ऐसा तो प्लीज माय लॉर्डशिप सेंड इट फॉर BLC DC consideration compromise हम लोग कनेक्ट
the matter again on Monday at 2:30.
Petition number 3148 may can be connected.
Please my lord हो जाएगा लड़की लोग मैं मर जाएगी करके बोलते कौन सकता है हम कॉम्प्रोमाइज करने के लिए मीडिएशन के लिए रेफर कीजिए मीडिएशन मेनी केसेस सुप्रीम कोर्ट पिटीशन
I think the session is about to commence. So there's some internet issue as well. तो जैसे कि आप सब देख रहे हैं फिलहाल ये अब जो मामला चल रहा है हाई कोर्ट का कहीं ना कहीं अब ये एक कंक्लूजन पहुंच रहा है. जब चीफ जस्टिस अपना डिसीजन सुन रहे हैं क्योंकि टेक्निकल एरर हर जगह पर हुआ है, वहाँ कोर्ट पर भी हुआ. तो यू कैन सी एडवोकेट कालेश्वरम राज यहाँ पर है और बहुत सारे लोग हैं. टेक्निकल इशू हाई कोर्ट से ही हुआ है. तो एवरीबॉडी इज बैक. संजय हेगड़े जी यहाँ पर मौजूद हैं. एडवोकेट देवदत्त कामत भी यहाँ.
We are unable to see the honorable court. May please, Lord. May so please. Lord, I beg to appear for the petitioners in my lord's WP 2880 of 2022.
My lords, I appear in 2146 of 22, which is the first case.
Please give the name.
Yes, my lord. No, that is Aisha Sanjay.
In mine is the first case. If your lordship pleases, writ petition 2146 of 22, it is Aisha Haji Almas.
2146 of
22.
Yes.
Aisha Haji Almas. That is the case from Udupi. My learned friend appears, Mr. Kamath appears in law from
2880 of 2022, my lords. Lord, this petition was heard, my lord, before the learned single judge, my lords, at length on day before yesterday. So, my lord, if I can just make a few brief, my lord, submissions, then my learned friend can.
You are appearing in 2880.
That's right, my lord. That's right, my lord. Lords, I have prepared a written note. Lords, Sanjay, just
may I begin? I have something which will save the time of the court. Please, my lord. My lords, there are several cases out there, and the referral by the learned single judge was largely on the question of whether this is an essential religious practice, and that question no doubt squarely arises. It was heard at length. Mr. Kamath is right. He did address the court for nearly a day on that. But, my lords, there is also a principle in law which says that constitutional questions necessarily be decided if they can be decided on other statutory grounds. My lords, in this case, it will be my respectful submission that while I fully adopt and I will be also arguing the constitutional questions, there are also statutory questions and questions on the rules on which the facts of this case may be disposed of. Please, my lords. My lords, the lead judgment for this principle is a judge.
We will have to understand what are the questions involved.
Please, my lords.
Then only we can decide.
That's right, my lord.
Please, my lords. My lords,
First, give the key facts of the case.
Please, my lords.
Give the key facts of the case and then come to the legal position.
Please, my lords. The brief facts
Yes.
of the case that I represent, which started off this entire chain of events, arise from my hometown of Udupi, my lords. In the government PUC college, 2146 of 2020. My lords, in this petition, the brief facts are set out at para 5 on page 12.
Yes, a direction has been sought to attend classes with their headscarf without
Please,
any bias and discrimination.
Please, ma'am.
Yes.
Manoj, may I just place the facts as to what happened? And I'm aware that there is no counter as yet filed by the private respondents because they probably were served only yesterday. Manoj, it appears to me on my reading of the facts,
whether the state has filed the
state has filed a response. The state has filed a comprehensive response on law. On law.
All right.
Please, Manoj. The only reason that I'm placing the facts are that it appears on my reading of the facts that it was a small thing within a college, which probably due to lack of timely administration has been allowed to go beyond control. Para 5, my lord, may please. Para 5 of the petition, my lord. I'm sorry, my lords, I was waiting for. There seems to be some disturbance, but if your lordships can't hear me, please tell me.
Yes, we are.
Please,
we are hearing. Yes.
Please, Manoj. The petitioners are students of the government pre-university girls' college and are wearing their regular headscarf over the college uniform. And respondents 6, 7, and 13, who are teachers there and the principal, insisted that the petitioners remove the headscarf by shaming them due to their conduct and invoking their religious identity. In fact, in spite of this, the petitioner continued the same, convincing their alma maters that it is part of their religious and social culture and wearing headscarf is not coming in the way of school discipline and their education. In the month of August 2020, respondents 6 and 7 rebuked the petitioners and told them that their parents had sent consent letter at the time of admission, accepting terms and conditions of the school, and specifically admitted that the wards won't wear the headscarf, so now they can't reach the same. Respondents number 6 to 14, whenever they found the petitioner anywhere in the college, scolded them, threatened them with marking absent in their attendance and not awarding internal marks. Respondent number 13 specifically informed petitioner number 5 that in the past also some girls used to wear headscarf to teach a lesson to them. She incited other students to pull their scarf. If you and other students don't fall in line, they will have to face the same treatment. Since September 2021, the petitioners faced discrimination in their class, and whenever the respondent took their classes, removed the petitioners from their class, marked them absent, made them stand outside as the class as punishment, and it is still continuing till today. In the month of December, parents of the petitioner went in to speak to the respondent number 6, that is the principal. He replied that now exams are going on, he will discuss the issue after exams. And when they demanded about the consent letter, which the college teachers used to refer to the petitioners, then the respondent number 6 candidly accepted that there is no specific condition regarding the headscarf and it is common form regarding maintaining school rules and discipline. From the last week of December 21, after the exam class teacher did not allow the petitioner students to allow class, used to send to the respondent number 6 office to take permission and inform them either to remove their headscarf or get permission from the principal through their parents. Even when their parents came to college to speak to the principal, respondent number 4, they compelled them to wait the whole day without meeting. The conduct of the respondents 4 to 12 appeared to be to frustrate the petitioners and their parents and compel them to concede before them. On 30th of December 2021, seeing no result, the students approached respondents 3 and 4, who are the district education officers, with their representation to intervene in the matter, finished their ordeal, and after receiving the representation, respondent 3 called the principal and scolded him for not allowing petitioners to attend class and directed him to allow the students immediately. Copy of the presentations are there. On 1st of January 2022, New Year's Day, respondent 6, the principal called a meeting of the college development committee, which had no legal sanctity and in composition of political entities to interfere in the management and functioning of the college for the political agenda. The chairman of the CDC, the respondent 15, declared that the petitioners will not wear headscarves. If they continue, then the other students, according to the narration, Hindu students, will wear mufflers, saffron shawls to counter them and blend the issue into communal color. After this meeting, the petitioners were not allowed to attend the college on all working days and were made to sit outside of court classroom like a culprit on 13th January. Seeing no hope and being targeted from every corner, petitioners thought of doing a protest in front of the college gate along with the petitioners to seek their right of education, which was continually denied. At that time, respondent 6 principal called the local media at the insistence of respondent 16, the MLA, which took petitioners with placards to circulate in social and electronic media to divide society much. Then, on 14th of January, the petitioners went to the college. That time, the principal called them in his chambers, scolded them for conducting protest in front of college and making a media issue. Subsequently, he called the respondent to write an apology letter. The respondents threatened petitioners with their gestures and gave a blank paper to forcefully write apology. When they refused, they called respondent number 13 as well, who manhandled them physically and threatened to spoil their education completely, and they cannot help as entire system is against them. Then, my lords, then other leaders got on, but this is the basic perspective. So the reason
we understood the problem. Yes.
Please, my lord. This is
what is your
my respectful submission is that I have gone through the entire act, through the rules, and also an interpretation of the rules. My respectful submission is that in the act, in the Karnataka Education Act of 1983, there is no specific provision which deals with uniform.
Do you mean to say that there shall not be any uniform?
Please, I don't mean to say, let me complete the argument. My lords, there is no provision for a uniform. The state relies on certain rules, which
just one thing. We will just make a request to the media in general that please don't report any observations made by the court during the arguments without seeing the order which we will pass ultimately. So there is a request to the media in general that please.
जो starting वाला था, तो now will be going back. So I think this video has ended, the live video, so I will be taking out the new link which is happening. I think इसके बाद जो है live अब हाई कोर्ट से नहीं आ रहा है the statement whatever it is. जैसे आपने देखा कि पिछला जो मैंने आपको बताया था that was the only thing live. उसके बाद से लाइव डिस्कनेक्ट हो चुका है हाई कोर्ट से, जैसे कि आप देख रहे हैं nothing is coming up now as live. तो जो भी डिस्कशन चल रहा था आपने देखा कि लास्ट में संजय हेगड़ा जी की बात जो है कामत जी बात कर रहे थे और उसके बाद से लाइव कट हो चुका है. आई डोंट नो व्हाट द रीजन इज. लाइव जो है वो अब नहीं आ रहा है. ये एक वीडियो है 3 आवर्स बैक. तो अब फिलहाल के लिए लाइव वीडियो जो है हाई कोर्ट से नहीं आ रहा है. आई थिंक क्या जजमेंट देते वक्त लाइव नहीं करते, बट यहाँ पर है. तो ये तो हमारा ही वीडियो है जो लाइव चल रहा था. So there is no live video. High Court waiting. तो जैसे कि आपने देखा कि फिलहाल बहुत देर से हम लोग सब बने हैं लाइव, और मैं सभी मेरे जो यूजर्स हैं कमेंट्स कर रहे हैं, मैं आपसे रिक्वेस्ट करता हूं कि प्लीज आप लोग हेट कमेंट्स ना करें, एक दूसरे के ऊपर आप लोग गाली गलौज ना करें और एक दूसरे के रिलीजन के बारे में कुछ ना बोले प्लीज, क्योंकि इससे हेट बढ़ता है. हेट बढ़ने ना दे. आप सब वी रिस्पेक्ट ऑल रिलीजन्स, वी रिस्पेक्ट एवरीवन. तो इररिस्पेक्ट ऑफ जजमेंट का तो अपनी जगह है. जैसे कि मैंने आपको बताया कि ये जजमेंट आई थिंक आज डिसीजन होगा या नहीं होगा, या फिर पता नहीं कल जो है डिसीजन को लेंगे हाई कोर्ट. 2-3 चीजें जो अहम थी इसमें बताया गया है. जैसे कि कामत जी ने बताया कि कुरान की जो है सूरह नंबर 24 वर्स नंबर 31, जहां पर बताया गया है कि हेड स्कार्फ जो है और लॉन्ग स्लीव जो है वो एसेंशियल है हर लड़की को पहनना जरूरी है, तो उसकी बात लेते हुए उन्होंने एसेंशियल चीज में डाला है। अब देखना ये होगा कि चीफ जस्टिस इस पर क्या डिसीजन लेते हैं। इससे पहले मैंने बताया कि आपको संजय हेगड़े जी ने ये बताने की कोशिश की है कि जो भी जो है रिलीजन की प्रैक्टिस, उन्होंने एग्जाम्पल दिया, जैसे B.R. अम्बेडकर जी को जो है जब पढ़ाई वो करते थे तो उन्हें अलग बिठाया जाता था, एक जो है थैले के ऊपर जो है कपड़ा भी नहीं रहता था, तो उस पर बैठ के पढ़ाई करते थे, तो इस तरह का एक सेपरेशन हुआ था। तो वो चाह रहे हैं कि इस तरह का सेपरेशन ना हो, बच्चों को यूनिफॉर्म देखकर उनके रिलीजन का पता नहीं चलना चाहिए, इक्वलिटी रहनी चाहिए। संजय हेगड़े जी इस तरह की बात कर रहे हैं। वहीं पर कामत जी ये बोल रहे हैं कि इक्वलिटी अगर हेड स्कार्फ पहनने से कोसे लोगों को धर्म को कोसे प्रॉब्लम हो रहा है, हेड स्कार्फ क्योंकि किसी के रिलीजन में आता है तो वो पहनना जरूरी है, इस तरह की बात जो है उन्होंने कहा है। और उसके बाद आप देखते हैं कि हाई कोर्ट से जो ऑर्डर अगर पास हो चुका है तो वी विल बी हैविंग, मैं वो भी आप लोगों को दिखाऊंगा कि एग्जैक्टली अब ये मामला कहाँ पर जा रहा है, क्या चल रहा है। टॉप स्टोरीज मैं आपको स्क्रीन पर ही शेयर करता हूँ। लाइव लॉ करके एक बहुत ही अच्छी वेबसाइट है, उसे आप जो है जरूर देखें। मैं आपको स्क्रीन पर दिखा रहा हूँ। दिस इज व्हाट वी हैव। कर्नाटका हाई कोर्ट जो है, ये तीनों जो है जज हैं जो इस केस को देख रहे हैं। लाइव अपडेट्स। अच्छा, तो हियरिंग जो है एंड हो चुकी है, यहाँ पर बताया जा रहा है, आप देख सकते हैं। और ये मैटर अब जो है मंडे जा चुका है, मंडे, ओ माय गुडनेस, फ्राइडे सैटरडे संडे 3 दिन छुट्टी के बाद अब ये आएगा। एडवोकेट रेज ऑब्जेक्शन टू द इंटरिम डिसीजन Chief Justice, we will restrain everyone from adopting religious practice while we are hearing. अच्छा, Chief Justice कह रहे हैं we are ready to decide the issue at the earliest, but we feel that peace and tranquility should be restored. Till decision, you should not insist for wearing these religious clothes which are not conducive. Chief Justice कह रहे हैं कि जब तक डिसीजन नहीं आता है, आप लोग जो है ना स्कार्फ पहने ना शॉल पहने और कॉलेज को वापस से स्टार्ट करें, और मंडे को इसका डिसीजन लिया जाएगा। इस पर कामत जी कह रहे हैं कि भाई आप इस तरह से अपने राइट्स को सस्पेंड नहीं कर सकते हैं। आप ये बोल रहे हैं या तो खाना खाओ या तो पानी पियो, दोनों एसेंशियल चीजें हैं, ये बता रहे हैं कामत जी। उसके बाद चीफ जस्टिस कह रहे हैं कि भाई थोड़े दिन की तो बात है, कोऑपरेट करें। और हेगड़े जी कह रहे हैं फॉर अ फ्यू डेज वी कैन नॉट आस्क टू बी सस्पेंड आवर फेथ। चीफ जस्टिस कह रहे हैं वी विल रिस्ट्रेन एवरीवन फ्रॉम अडॉप्टिंग रिलीजियस प्रैक्टिस व्हाइल वी आर हियरिंग। ये बहुत इंपॉर्टेंट बात है। चीफ जस्टिस कह रहे हैं कि जब तक हम ये सुन रहे हैं तब तक आप अपने रिलीजियस प्रैक्टिसेस को आप अडॉप्ट ना करें, रिस्ट्रेन करें, यानी कि आप फिलहाल के लिए कॉलेज जाएं हेड स्कार्फ ना पहनते हुए, हेड स्कार्फ ना पहने ना शॉल पहने, फिलहाल इस तरह का कोर्ट फैसला ले रहा है। और एडवोकेट्स रेज ऑब्जेक्शन टू द इंटरिम रिलीफ तो दीजिए, बताए तो वो भी जो है मंडे को आएगी। अब ये मामला जो है खत्म हो गया फिलहाल के लिए। ऑलराइट, तो फाइनली हमारे ऑडियंस जितने सब्र से यहाँ पर वेट कर रही थी, इसका ये मामला है कि मंडे को कंक्लूजन आने वाला है। फ्राइडे सैटरडे संडे तीनों दिन छुट्टी, मंडे के दिन आएगा। चीफ जस्टिस ने जब तक ये कहा है कि जब ये मामला कोर्ट में चल रहा है तब तक आप कोई भी रिलीजियस प्रैक्टिस वाला जो है वो कुछ ना करें, ना स्कार्फ पहने ना शॉल पहने, कोई भी रिलीजियस की चीज को आप नहीं करें और कॉलेजेस को रिज्यूम करें। इस तरह की बात जो है फिलहाल चीफ जस्टिस की तरफ से आई है। तो बने रहिए हमारे साथ। उसके बाद हम फ्लैश न्यूज और जो अलग अलग थोड़े वीडियोस हैं वो बना के मैं आप लोगों के सामने आता हूं। तो टिल देन प्लीज टेक केयर। हियरिंग तो खत्म हो चुकी है, तो देखते हैं। फिलहाल के लिए अगर आप देखें तो बहुत ही न्यूट्रल जजमेंट आया है। वो कह रहे हैं कि भाई फिलहाल 3 दिन का ब्रेक दीजिए, 3 दिन के बाद हम बात करेंगे इस बारे में। फिलहाल स्कार्फ्स को अलाउ नहीं किया जाएगा स्कूल कॉलेजेस के अंदर, और ना ही शॉल्स को अलाउ किया है। शॉल्स तो लेटर स्टेज में आए थे, स्कार्फ जो थे पहले से थे। तो ये सारा मामला क्या है, विल बी गिविंग यू एन एक्सक्लूसिव वीडियो ऑन दिस। थैंक यू सो मच।